broader, and both deliver something of a refresher of the conversation we had last time on the VRA very quickly, but then also move into the sort of challenges you might expect in litigation, the sort of challenges you might expect from contests of your work, that would help you better assess. This is designed in order to help you better assess the sort of personnel you'll want to bring in from the get-go. So very much a part of the same conversation you were having moments ago that I happened in on. This is designed to help you better appreciate the work that the council will do so that you can figure out who you want as that people or those people. So if I might, I will try to share my screen once again and see if I have as little success this time as I did last. Theoretically, you're all looking at something that says Voting Rights Act litigation, VRA litigation. Excellent. And because in this mode, I can only see some of you, if you have questions in the meantime, please shout out. That's the only way that I'll be able to see that you have a question. Either, I don't know whether you've been asking people to use the participants list and raising a hand, or whether you've been otherwise collecting engagement, but I'm happy to pause if you signal to me that you want me to pause. So just to begin briefly, a refresher, where we last left our heroes, we had talked about 3 basic rules for staying out of trouble when it comes to the use of race and ethnicity in the redistricting process. Trying to distill down, obviously, a lot of much more complicated stuff, but I think these rules accurately capture the bulk of what you'll be asked to do, and so they may be helpful as a mnemonic device for a lot of other detail beyond. First, don't set out to hurt voters based on their race or ethnicity, either by dividing and diluting what's generally known as cracking, or by over-concentrating voters in order to tokenize, essentially, in order to bring all voters of a certain type into one district to deprive them of influence elsewhere, what's generally known as packing. Doesn't matter if the lines are pretty, doesn't matter the ultimate motive, we did this in order to X. If your goal was to use race in order to injure, not okay, flat out. The second rule, comply with the Voting Rights Act. Obviously, that's a big chunk of what this conversation is today. Actually, rules 2 and 3 go together, and that's part of the point I want to make. So the basics of the Voting Rights Act have to do with a certain set of thresholds. Below those thresholds, there's no obligation to draw districts under the Voting Rights Act. You may choose to draw around various communities independent of this. The Voting Rights Act is not the maximum that you can decide to accommodate race or ethnicity. It sets a floor, but not a ceiling. So that floor asks 3 basic questions to determine whether there's an obligation, whether you all have an obligation to draw particular districts in and around minority communities. 1, are there sizable, relatively concentrated minority communities? Could you draw a district such that about half of the electorate in that district was a minority group or a combination of minority groups voting together? So they're big enough and reasonably compact enough to be district size. Second question, do minority communities have distinct electoral preferences, and this is a shorthand, different from other communities in the district? So do one or more minority groups have a distinct set of electoral preferences? Does the remaining population in the district have a different set of electoral preferences? Normally that's going to mean that the minority communities get outvoted most of the time. And the third question, did they or do underrepresented minorities that haven't yet achieved a proportional degree of district control across the state, do they face discrimination? And are there lingering impacts from historical discrimination that they face? In, unfortunately, most parts of California, that answer to that third question is going to be yes. We have a history of not being particularly kind in much of California. But you'll also want to bolster that with local historical information and not just rely on, across the board, not just rely on statewide stereotype of any kind, but in this analysis as well. If those three questions are yes, if there are sizable, relatively concentrated communities of minority groups with different preferences from the rest of the electorate, and if they did or do face discrimination, then the question is, can you design districts to give minorities a fair shot? Yes, please.
It's Commissioner Sinai. Can you talk a little bit more about do they face discrimination, just so that we can have a better understanding?
Yep. I actually don't have a slide on that one. Normally I would flip to the next slide down. That refers to a group of characteristics, a group of present and historical factors called the Senate factors. So-called because they reflect what the Senate Judiciary Committee wrote up extensively when amending the Voting Rights Act in 1982 as a list of factors to try and suss out whether there was past discrimination or present discrimination or the lingering impacts of past discrimination. So that includes things like, is there discrimination in the voting process, both official and unofficial? Are there slating practices that generally work against minorities? Are there features of local elections that generally work against minorities? Things like at-large districts that subsume minority preferences. Is there a real hurdle or burden to minorities' participation in campaigns through campaign finance structures or through local organizing? It also embraces discrimination outside of the voting process that might have an impact on the voting process. So historical educational discrimination, housing discrimination, general racial appeals in campaigns or beyond campaigns that might tend to work to minority groups' disadvantage in an electoral context, even though the discrimination itself was outside of that context. There's a list of between 8 to 10 factors that courts generally consider. And you'll actually find that list in my last presentation to you, but that's what that's about. And it's a very guided, structured, checklist is the wrong way to approach it because you don't have to hit every bullet on the list. It's a guided, structured analysis for, are there real problems beyond just current voting patterns that give reason for concern?
Thank you.
You bet. Good question. The third factor, or the third rule, is make sure when you are considering race or ethnicity that you consider other factors at the same time. There's a constitutional limitation on race predominating, unless there's a really good reason. The courts have always said that compliance with the Voting Rights Act constitutes a really good reason, but you don't ever want to have to get there if you can avoid it. So to the extent you can draw districts conscious of race and ethnicity without allowing race and ethnicity to predominate, to really drive the discussion exclusively to the subordination of everything else, that leaves you on safer legal ground. The analogy I presented last time, everybody knows it's important not to speed. But if you spend the entire time in a car driving staring at the speedometer and ignoring everything else, including traffic, including weather, including other cars on the road, including where you're going, including music, including in-car comfort like heat and air, including passengers in the back seat kicking up a storm, you're going to crash. So watch the speedometer, but also watch the other stuff. And if you are watching the other stuff while also being very conscious of the speedometer, that's where you don't run into a problem. Avoid fixating, I guess is a better way to put it, on a particular racial number. It's fine to have a number in mind, but also consider other aspects of a district whenever you're drawing, and that provides some insulation. So that's a brief refresher, overly brief refresher. But what I really want to do is get into how this actually plays out in a real world context so that you can start processing what this means for your choices of who you'll choose and how you engage them. When the lawsuits come, and I put it that way because the lawsuits will come, unfortunately. By the way, you should not take the fact of a lawsuit as a sign that you have done anything wrong. You should take a fact of a lawsuit as a sign of somebody's unhappy, but that's very different. And you should not be alarmed by the fact of a lawsuit if you've done what you've been asked to do by the council, by the Constitution, you'll prevail. And that's the way the system should work. You're going to get sued. And you're going to get sued from two different directions, or the options will come from two different directions on this. One allegation is that you've made an improper use of race, that you violated Rule 3, that you were staring at the speedometer so much that you crashed. And another allegation from the opposite side will be that you paid insufficient attention to race. You had a voting rights obligation that you ignored, or that you did not live up to. Avoiding the improper use of race, that staring so hard you're going to crash, is really pretty straightforward. It's fine. I really want to emphasize this. It's fine to consider race and ethnicity when you consider where to draw districts. That is totally okay. If you don't set out to overpack voters inside a district and dilute their strength elsewhere, if you don't set out to divide and splinter minority groups, that is to draw lines through a minority group so that its influence is dispersed, and you consider factors in addition to race and ethnicity, and when you produce the report that California law asks you to produce at the end of the process, you explain that you use those other factors in addition to race and ethnicity. Things like communities of interest, things like political boundaries, like cities and counties and neighborhoods, things like the California's unique compactness standard based not on pretty geometric shape, but based on bypassing nearby population. If you consider those things in addition to race and ethnicity, and you say as much, that will actually help avoid or fight back against allegations that you have improperly used race. The other side of the coin, avoiding insufficient attention to race. The litigation is going to come in these places instead, right? They're going to challenge whether local minority groups, whether you paid attention to local minority groups that were large enough to be over 50% of the CVAP, the citizen voting age population, either separately or together. That is, either groups on their own or groups considered together if they have voting preferences together. That's an if. So if there's a large minority group that you ignore, that's trouble. If there are local minority groups that have distinct political preferences, so challenges will come about your evaluation of their distinct political preferences. That's the racially polarized voting studies that I know I heard Commissioner Sadwani talking about just before we got started with this point. You'll want to consider both distinct political preferences for individual minority groups, but also occasions where minority groups tend to vote together, where, for example, African American and Latino voters may have common political preferences, and that may be true in some parts of the state and not true in other parts of the state. That's a localized determination and relentlessly based on actual facts on the ground. You'll also want to consider the differences between primaries and general elections. So there may be some common choices in a primary, or there may be some common choices in a general election. You'll want to consider them both to make sure that you're giving voice to make sure that if there's a sizable community with particular distinct preferences, they are actually drawing a district that provides a fair opportunity for political power that arrives through both the primary and the general election process. And with the top two primary, it's a little more complicated than just deciding if somebody can win the Democratic primary or the Republican primary, then that will automatically bring them to a viable general election. The top two primary complicates that a little bit. You'll want to make sure that you evaluate whether there's a history of discrimination with lingering effects, that same sort of analysis we just discussed, the Commissioner just asked me about, with a localized analysis. You'll want to find out, these are sort of the last two elements of a Voting Rights Act claim. Do minority groups have a meaningful opportunity in a proportional number of districts? So the Voting Rights Act does not impose an obligation if, for example, Latino communities constitute, I'm making up the number, 35% of the state, and already have a meaningful opportunity to elect candidates of their choice in 35% of the districts. The Voting Rights Act might create an obligation up to that point, but does not create an obligation beyond that point. And again, you can choose to account for race and ethnicity beyond what the Voting Rights Act creates an obligation for. I'm just talking about the legal obligation to do at least that to set up a floor. Finally, you're going to have to evaluate what it would take for local minority groups to have meaningful opportunities to elect candidates of their choice. And I'm going to get into what that means in the example in just a second. So I want to bring you through the wrong approach to help you see what not to do, and then talk about what a group of individuals trying to do a better job might actually do. And I don't want to use California as the example. I've been critical of some of the advice that the last commission got from their counsel in the past. Turns out they did something very similar to what happened in Virginia, but I want to focus on Virginia so that we can avoid talking about what happened in California. This is an easier example. It also went up to the Supreme Court. So in this extent, I know I'm right, because it's what the Supreme Court said. So here we have an example of the wrong approach. The trouble in Virginia, this is for the Virginia House of Delegates elections, their state assembly, effectively. When Virginia redrew the lines in 2011, those are the actual districts that you see and outlined there. And the districts that are colored in were the districts presented on the right-hand side of the slide. Individual districts with a certain percentage of African-American voting age population. The assembly found that the gold district, right, sitting there in the sort of southeastern section of Virginia, actually needed 55% of the voters in that district to be voting age, 55% African-American voting age population, in order to give the African-American community there a reasonable, equitable opportunity to elect candidates of their choice. Based on some past elections, based on demographic data, based on political analysis of how voters voted in the area. And I want to emphasize, they didn't do formally racially polarized voting studies beforehand. They had a different means of evaluating elections. They looked at a number of very close elections, and they talked to the representatives there to determine at what point they thought the line would tip. It wasn't particularly rigorous, but it was informed by something other than guesswork. It was informed by actual past election results. And so in that gold district, they determined that in order to give African Americans a real opportunity to elect the candidates of their choice, there's a sizable group of African Americans in that area. The district had to be at least 55% Black voting age population. And then the legislature just assumed that that meant everybody had to be at 55% across the board, that the only effective way for African Americans to elect voters in any other part of the state was if they had 55% of a district. And so you can see that every one of the districts that are colored in here, every one of the districts that are listed on the right-hand side of the slide, had a African-American voting age population percentage of more than 55%, because the legislature took 55% from the one district and made it a floor across the board, independent of local facts, statewide. That got them in trouble. And it led to things like this. It led to, this is House District 95 in Virginia. That's small, I know it's small. The white dots represent represent Anglo voters. The black dots represent African American voters. The solid black outline represents the outline of the district. And you can see that the inside of the district is a whole lot more heavily African American than the outside. And they took census tracts, those are the little dotted red lines, and they selected census tracts that were very heavily African American in order to get up and over this 55%. And then there was a fight about whether they were staring at the steering wheel too closely. The litigation that came out of this used records, used legislative history from the legislature, where it sure seemed like they had taken this 55% assumption or stereotype and applied it statewide. And they took individual demographics from each of the challenged districts and they looked at population maps of each of the challenge districts in order to try and reconstruct, was race the predominant reason for drawing the district as it was? Was race the predominant reason why voters were put either inside the district or outside the district? Were they staring too hard at the speedometer? In litigation, this gets contested. So you can see that not every African American is put within this district. There are little pockets of black dots outside of the district lines themselves. And I've basically copied the exhibit from the defense here, pointing out, hey, we didn't do this everywhere. There are pockets of African Americans outside the district too. And there was long and painful litigation over whether this evidence showed staring too closely at the steering wheel, at the speedometer, or whether it showed attention to race but not racial predominance. The court ultimately found that given the comments on the record, and that given the patterns, that it sure looked like the reason House District 95 was drawn as it was, and the reason people were put inside or outside House District 95 was their race, way over and above anything else. That is, the legislature couldn't really articulate any other reason why 95 looked as it did, other than we felt we had to get over 55%. And that 55% wasn't justified based on the Voting Rights Act because they just used assumptions about what level of Black voting age population would be necessary to actually give a meaningful opportunity here. Virginia's politics are, well, they're not unusual any longer. They're not the stereotypical politics of the Deep South. In some areas, African Americans need more than 50% in order to have a reasonable opportunity to elect. In some areas, they need just about 50%. In some areas, considerably less than 50%. 42, 43, 44% provided more than enough opportunity for elect and had in the past demonstrated that districts with that level would reliably elect the representatives of choice of the African American community. And so once the court found that the legislature had been staring too closely at the speedometer, it looked to whether that could have been justified by the Voting Rights Act and found out no, that the legislature didn't do enough homework to show that the speedometer number it was fixated on was actually necessary based on the Voting Rights Act. It was instead an assumption taken from elsewhere. Curiously, the original district, that gold district, District 75, the basis for the 55% assumption, that district was grounded on fact. And so the court said, we actually find that you focused too much on race here. You focused predominantly on race here. You need a really good reason, but you have one. The Voting Rights Act actually does require that in that district, you have an obligation to create a reasonable opportunity for African Americans to elect, and 55% is a reasonable judgment about what that might be. So where there was no empirical basis for the assumption, the court struck down those districts. But even when the legislature was overly fixated on race, where there was empirical backup for, but we need to make this necessary for the Voting Rights Act, the court said, fine, that's okay. So the legislature got itself in more trouble than it needed to by fixating on race to the exclusion of everything else. But at least in the district where they had empirical support, the court said that's okay. Where they didn't, where they made assumptions that they just translated to elsewhere, the court struck down that part of the map. How do you do this right, rather than landing where Virginia landed? They started in the right place. So you can see that those portions of the Virginia map in the south and east, unsurprisingly, are portions where there are an awful lot of African Americans. This map is a heat map of the voting age population that's African American by precinct, and you can see the warmer colors, the red and the orange, are where there's relatively more African Americans in each precinct, and the bluer areas or the grayer areas are where there's relatively fewer. So the legislature started off with a good idea, which is go find out where there are sizable compact communities to see whether you have an obligation. That part was right. And I would encourage you to use your analysts and your counsel to help you find similar heat maps in California of individual racial and ethnic groups, but also of groups in combination that show you where there are sizable communities that you might have an obligation for. That's step one. You'll find lots of them in California. Step two is to actually get some empirical support for whether you need to draw districts to satisfy the Voting Rights Act or not. This is the thing that the Virginia legislature sort of kind of did in the one district where it was based on past election results and didn't do at all in the other districts. And that's where it really ran into trouble. There are more empirically grounded techniques than just kind of guesstimating at what level of disparate elections, whether there's polarization in the community or not. It's generally called racial polarization analysis. I know you've discussed this before. We discussed this last time. This happens to be an exhibit that I have changed the labels on. This happens to be an exhibit from Matt Barretto from Los Angeles at the beginning of the decade, showing in particular one race. Each circle is a precinct. The circle sizes vary a little bit because that the number of voters in each precinct varies a little bit. And what you're trying to do in this sort of analysis is to look for patterns. Not every precinct is going to behave exactly in the same way. You're looking for an overall pattern. As the percentage of minority voters in the precinct increases, does the vote share for a particular candidate increase? And based on background knowledge, do we think that's probably because minority voters preferred a particular candidate? Sometimes the patterns are super clear. I would call this one super clear. There's a very tight cluster that shows this probably means, on my legend, this is not the actual legend, but on my legend, that African Americans reliably prefer one type of candidate. You're not done here. You also want to find out what the rest of the voters in the area look like. If you saw a pattern like that, and I've cheated, this is just the inverse of the same graph that I showed you a second ago, but if you saw a pattern like that, showing radically declining Anglo support for a candidate, the more Anglo voters there are, the less they support that candidate, then you would see that voting is pretty clearly racially polarized. This example here shows you very likely that African American voters prefer one type of candidate and that Anglo voters prefer another type of candidate, even though we can't see the individual racial designations on any individual ballot. Not all analyses will be this clean. Sometimes the patterns are not this clear. That's why you want to hire somebody to do the work who can evaluate, who can both perform the analysis and evaluate it for you to let you know, this is kind of clear, this is very clear, that's not clear at all. Actually, I can't find any pattern here. All of those are possibilities in various parts of California. This would be the next way to do this correctly, is to look for the large and sizable pockets, perform the analysis to find out if voting is polarized, and then set out about the final factors on your Voting Rights Act checklist. Is there a history of discrimination, or is there present discrimination using the Senate factors that we just talked about? Are there already districts elsewhere in the state that provide proportional opportunity to the minority group? And if there is a history and there's not already sort of the right proportion of opportunity elsewhere, then, okay, what's the right number? What speed limit should we be aiming for? That does not have to be exact. You don't have to peg to the X decimal place the precise the precise percentage of voters to give a reliable opportunity to elect. But you do want to have, and this is actually the legal framework, a strong basis in evidence for letting you know that you're in the right zone. The same racial polarization analysis can help you decide what the right number-ish is, or what the right range is, because it helps you know if, on average, 85% of Latinos prefer a particular type of candidate and 10% of Anglo voters prefer that same type of candidate. It lets you know the rough percentage of any one district that you have to have in order to give the Latino population a real opportunity to win that race. Kind of the outcome is essentially algebra. There's a lot of both art and science to developing the analysis itself, but once you have a rough feel for polarization in the community, it's not that difficult to indicate a rough range for a real minority concentration of voters. And again, I want to emphasize, in some communities, particularly given turnout patterns and other factors that go into real-world elections, that right range is going to be more than 50%. In some communities, it's going to be right around 50%. In some communities, it's going to be less than 50%. In large parts of Virginia and North Carolina, local African-American communities can reliably elect the candidates of their choice with 43 or 44 or 45% of a district, just based on patterns locally. And then the last step, consider other factors too. When you're doing this analysis, make sure that you're not only focused on whatever that percentage range is, but other local aspects that will help guide where the district should be. This is the right way to do it so that you're not stuck facing a map like this and having people question, okay, was the only reason you drew that map as it was because of race? So consider communities of interest, consider city and county and neighborhood boundaries, consider making the district compact based on where the population lives, not based on geometry. And that will help guide you to stay out of trouble in the right approach. That's a balance of living up to your obligations under the Voting Rights Act.
Professor Levitt?
Yes.
On these 3 points, the community of interest, city, county, neighborhood boundaries, and compactness, a lot of that will come later when we actually get the census data. So we can do the VRA, some of the stuff ahead of time, but we won't be able to map those VRA communities until we have the other data as well.
That's correct. So you can that's absolutely right. You can get started on a lot of this. You can get started on analysis of electoral results, because all of this is based on past electoral results. There's no reason you need to wait for the census data on anything for this. You can even get started on estimates of where minority populations are. This will formally come, the best data will come from the census when it arrives, but you can get started. We've got a pretty good estimate now, not just based on 2010 data, but based on constantly updated data, including the most recent is probably going to be from 2018 or so. So you can get started on this part now as well. And in places where there are sizable communities and where you've done that polarization analysis to know whether there's distinct preferences, you can look into the history or present discrimination in order to see whether you have an obligation. You don't need census data for that either. The last factor in sort of considering other factors too, that's only important when you are actually drawing the final map. And so you're right, you'll have to wait for census data on that. You actually may not have to wait for census data to start collecting information on some of those. City and county neighborhood boundaries aren't going to change in the census. Communities of interest, you can, if you choose, go out into the community and ask about various assortments of people with different interests in the legislature before you get census data. So you can do a lot of the pre-work for this. The only thing I want to make sure is that once you know there's a VRA obligation, when you're actually drawing a map in order to live up to that obligation, consider other stuff too that helps insulate the map from challenge.
One other question. I know I asked this last time, but my brain is a little foggy on remembering the answer. You know, we're drawing the lines for 10 years. How do we take into account the young vote, those who are under 18, who will be voters within those 10 years?
It's still a great question. That will continue to be a great question. So the answer is the law asks you to respond to the population that is there now. So if there's an obligation, the obligation's based on now. That doesn't mean that you have to ignore how demographics might change in the future. You can certainly consider that. But the law doesn't allow you to bank on the future in terms of living up to a present obligation. So, for example, in drawing a district that provides a real opportunity for minority communities to elect candidates of choice, you can't say, and there's case law on this, I know we're drawing this at a level where the opportunity doesn't exist now, but it's probably going to exist in 4 or 5 years. They call that the snowsuit approach. We'll let the population grow into their opportunity. That's not okay. But when designing districts that do live up to that present obligation, it is fine to consider how demographics are likely to shift in the next couple of years, as long as that's not a trade-off of future representation for representation now.
And one follow-up question, I'm sorry, is around the incarcerated population and how now it's going to be, we're looking at it differently. How do we consider that within the VRA?
So that you'll consider individuals who are incarcerated and their demographic components in the data that you hopefully will receive. So hopefully you'll engage a vendor to provide you the data. I don't know whether Karin's going to be able to do that or whether that's going to be somebody else associated. I don't know whether that's going to be within the statewide database or beyond, but you'll have to, the data you'll receive, hopefully, should allow you to consider these local demographic patterns in ways that include incarcerated populations that you are returning home, that have always been home for legal purposes, back to the communities where they were resident before they were incarcerated. They won't impact voting patterns much, because at least for individuals who have been incarcerated, they won't have voted, and they're not going to be able to vote until they're out of incarceration. So they shouldn't really impact the voting assessments, but they will impact the demographics. And hopefully when you receive these sorts of maps, you'll be looking to see with the information, with the data already pulled in. I'll say that for the most part, when you're talking about communities that are this sizable for state house districts and state senate districts and congressional districts, you're unlikely to change the heat map much based on reallocation of the incarcerated population. So it's important. I'm a big supporter of the change in the law. It actually provides better representation to all of those individuals, but it shouldn't actually change your assessment of where there's a Voting Rights Act obligation much at all. And that's simply by virtue of the size of the incarcerated population compared to the size of a California Assembly district. Good questions. So that was really essentially the end of the presentation. The one guidance I'd give to you is in all of this, and when you're thinking about engaging or retaining VRA counsel or VRA analyst or other people in this structure, you want to start early. Thank you. That was a magnificent segue. You want to start as early as you can with getting the data and with considering the data even before the Census Bureau provides you. You want to give yourself time to consider not just individual minority groups, but blocks of multiple minorities who may or may not be voting together. And you want to give yourself time to try different combinations without getting locked in to one particular approach that leaves you blinded to, well, what if we did this slightly differently? That's easier said than done. And the best way to effectuate that is to draw up some proposals and then get feedback on them, and then be prepared to throw them out in part or in whole in drawing up a different set of proposals. The more you can remind yourselves not to get too terribly attached to first drafts, the easier that will be, which is hard as a human. And that's really the end of the presentation I had. I'm more than happy to take other questions if you have them.
I do have a couple of questions. So first, and I think this is a question that I posed to Professor Barreto when he was with us. I still have a little bit of discomfort or uncertainty about how we tease out or how we isolate the effect of candidate quality. Because we talk about, we talk about candidate of your preference, but sometimes, there's just a candidate that's bad, or there's a candidate that wouldn't necessarily fit into a category that a group would normally vote for, but because the quality of the candidate is so good, they end up voting in a way that doesn't fit their historical pattern. So how do we, and I know that we don't necessarily have to be the ones doing that, but I want to make sure that, that's there, we understand that phenomenon and how it could be dealt with.
Yeah, so that's absolutely right in terms of the empirical reality. That happens. Obviously, that happens. The way that researchers generally address it is twofold. One, don't ever just use one race to gauge racial polarization. So the right way to do this is with a blend of several races to see whether the patterns are consistent not only across group and across precincts, but across time and race. Not racial preference, across time and candidacy. So if you find a pattern from 4 different elections that's the same in 4 different elections or very similar, that's going to tend to cut against this was a really bad candidate or really bad candidate answer. And the second is to have somebody to engage somebody who either knows themselves or is willing to do a little bit of research into the qualitative measures of particular races to see whether there are those sorts of anomalies. It is embedded in the law of the Voting Rights Act and the law of doing racially polarized voting analysis that there may be weird races that you count but discount a bit. So it's not like you eliminate them, but you give them less weight when you're assessing preferences because something odd happened in the race where there was an odd candidate quality. That it's not true that every race is treated exactly the same, every candidacy is treated exactly the same when you're doing this polarization analysis. And that means you want to retain somebody who either, again, knows or can find out whether there are some super bizarre qualities to a particular candidate in a particular race or a particular issue that sunk one candidate or elevated them, that mean that they're not particularly representative of how the community feels. The goal in all of this is to try and assess how the community feels, how the community votes, not the success or failure of any particular candidate. And so optimally, you want to talk to the community to say, hey, was there something weird going on in this particular race? And to choose several so that you insulate yourself against that.
And somewhat related to this, I mean, how do we deal, we talk about citizen voting age population, but that doesn't guarantee that those people are voting. How do we deal with ascertaining preferences of non-voters that we really should be? I mean, to me, people are out there who aren't voting because they just don't like any of the candidates, but theoretically there's a world in which they would be voting.
True. Or they're not voting because they know they're going to lose because the districts aren't currently built for them. And I think I used this analogy the last time. If you put me in a foot race with Usain Bolt, I might not try super hard because I know what the answer is going to be before I even get off the blocks. This is very much related to Commissioner Sene's question. The law asks you to take the voters as they are. You can acknowledge always that designing a district differently may lead to different turnout effects. And so voters may show up in the future where they have not showed up in the past. But the analysis asks you to take the communities where they are in terms of who has actually voted and what preferences does that demonstrate. That is, the law generally, it asks you not to assume flat out. That's the sort of the biggest overarching statement I can give. It doesn't say you have to blind yourself to what might happen in the future, but it asks you not to make your decisions based on assumptions. So just like you take the composition of the district as it is and not based on who might be coming into the electorate in the future, you take the political preferences and the voting preferences of the electorate as they are and not what might change in the future. Even though if you do this right and you're creating a district where the Voting Rights Act has an obligation for a community that had no opportunity before, you would actually expect to see a change. You would hope to see a change. That's what the Voting Rights Act is for. So you're right, that happens, but the law asks you to evaluate the community as it exists.
Thank you. Commissioner Sinai?
Sorry, I'm just so intrigued with all of this now. I didn't think I was a data person. So how do we look
for a data person, by the way, that really warms my heart.
Well, I guess I always have. I guess I've always have been a data person, but how I like to put faces on data is more what I see myself. And so the question is, 2020 has been the election that just happened was an unprecedented election. And that makes me giddy. I love that people voted from all walks of life and stuff. How is that going to affect how we look at a lot of this?
So, first of all, the circles will probably be bigger in 2020. The precincts, that's actually not just precinct size, that's the number of voters within each precinct, and those will get bigger than they have been in the past. That I agree with you. That seems like a good thing. Your questions are all relating to each other. This relates to the question of what if we get a weird race? And there may be plenty of ways in which the presidential race of 2020 was not the norm for anybody across the board. That's part of why you want to choose a selection of races to view racial polarization so that you're not capturing any one anomaly. You may find that first of all, assume there's a pattern. Like in some places you may find there's no pattern, right? That there is no real reliable polarization based on race. That's possible. Will often depend on which racial or ethnic groups you're considering at the time. There may be one group that's quite polarized, and there may be a different group that's quite polarized in another part of the state. But assume there's a pattern. You may find that the latest race followed the pattern, or you may find that the latest race didn't quite follow the pattern, but that's why you're looking for an overall pattern. So if it really stands out as weird, and not just weird in the presidential race, but weird in a number of other races in 2020, that may mean you've got a changing electorate. If it doesn't stand out as weird, that may mean you've got more of the electorate than before, but according to very familiar patterns.
Commissioner Sadwani and then Commissioner Toledo.
Sure. Just to add on to this from some of my own research, I know Commissioner Sinai are asking to put a face on this, right? And so I very strongly agree that having multiple data points and multiple pieces of analysis from various elections would be ultimately very helpful. In this commission, I haven't really talked at all about my research, but it's all published and out there. So there are pieces that I've done specifically, for example, looking at Asian Americans in Orange County. I would argue that that is a community that is very much in a process of changing. So a piece, and I'm happy to share it with you, it's in the Washington Post, that looks at the Asian American community in Orange County in a handful of districts, will show that there is this kind of variation from one election to the next. In one district, for example, when what I found was that while there was a predominance, there was this push for re-electing Republican incumbents until there was a Chinese American on the ballot. And I found racially polarized voting amongst the Asian Americans. In the 2016 election, right, with Hillary Clinton, she had won that district. And I find it was due to the polarization of the Asian American community in support of Hillary Clinton in that district alone. Similarly, in 2018, that same district sent a Democrat who was a Latino to Congress. Again, Asian Americans were polarized in support for that candidate. However, in this past election, an Asian American Republican has won. Did they switch their vote? Is it because there was greater turnout? I don't have the answers to that yet. The vote's not certified, so hopefully we'll be able to take a look at those kinds of pieces. But my sense is when we look at, when it comes to actually looking at some of these areas, yes, we're going to need a pattern in those districts, but we might also need to drill down more locally to better understand how, people in Fullerton might be voting in local city council elections versus other elections. And we might need to start thinking about those kind of local areas, which is where it ties into those communities of interest as well. Similarly, I've studied Latino voters as well, under the constraint of the top two primary. When you arrive at a general election with two Republicans on the ballot, one being Anglo, one being Latino. What we saw is that with my co-author, what we saw was that Latinos were polarized towards a Latino candidate, regardless of the fact that they were Republican, right? So I think all of these kinds of considerations we can begin looking at now so that we have a sense of, okay, well, where is it that we need to go? What additional information might we need to make the best kinds of decisions, right? Because the RPV analysis isn't going to be the only data point. It will be one, right? It'll be an important one, but we'll have to kind of have a sense of, okay, we should probably be focusing in here and really having a lot of those conversations in those areas, right? When we go out to do the public testimony and receive public testimony.
And what Commissioner Salvani is speaking to is very, first of all, it is very in line with how the courts actually treat these races and very in line with just not making assumptions. Even assumptions that you feel like you may know how the community feels. The data will show whether your assumption is, or your history or your sense is right, or might have been right but is now wrong, or wasn't right all along. It's really important to have that empirical data to back you up on how different groups vote in different places.
Great. Commissioner Toledo.
Thank you. Given the likelihood of legal challenges, I'm just wondering and curious about your thoughts around the changes to the Supreme Court, the composition of the Supreme Court, and whether there's any insight as to changes to the VRA or any thoughts about how the interpretation might differ with the new composition.
It's a really good question. I want to premise this with similar to Commissioner Sinai, your obligation at the moment is to take the law as it exists and not how it will. So I realize that's not what you weren't suggesting anything different. I don't know that it's clear how this court will view these issues that I've talked about and whether there will be departures at all, much less radical departures. There are the basic push against stereotype and against assumption. I was critical of the past commission and of other states that adopted a similar sort of numbers-only demographic approach without political reality. In 2011, well before this court had the opportunity to evaluate some of those cases in 2016 and 17 and 18 and 19. And that was a very different court that evaluated them later in the decade, and they felt about the issue exactly as I had thought they would, which was exactly as prior courts had. So even though the court as a whole changed composition over the course of the decade, their approach later in the decade was exactly what I thought what it was and what I thought it would be in 2011. And I don't know that that part is going to change much at all. Similarly, the courts have been, just like the court says, don't make assumptions, and I would expect that to continue. The court has always looked to the basics of the Voting Rights Act, the sort of provision that you have in front of you, not, I'll leave aside some changes the court made in 2013 to something that you no longer have to consider. The court has always held up that part of the Voting Rights Act as the example of good, valid congressional litigation when it's striking down other things that do bad things. So it has always turned to, unlike the Voting Rights Act, this thing that we're evaluating here doesn't do one of the following things. And that has been true across administrations, across appointees, sort of independent of the composition of the court. Even when members of the court are fighting about application to particular circumstances, they tend to take the basic core of the Voting Rights Act that I've described to you today as an example of the good stuff. And so I don't know that I would expect that to change either. On the margins, it's entirely possible that the court's interpretation of some elements of these things may change. I don't know. I don't know that we'll know until your map or others has the opportunity to get presented to them. But actually, just like the law asks you not to make assumptions, I don't make assumptions about what the court's going to do outside of the context of a particular factual scenario, outside of a particular case they're given. So it's a really good question. And the straight answer is, in some cases, I would expect nothing to change with respect to what we're talking about today. And in some cases, it might well change, but I don't really have a good feel for how. And I don't know that the simple membership of the court tells me.
Very good. After our break, we will have Commissioner Taylor and Commissioner Yee, but we are at the point where we are required to take a 15-minute break. Actually, let's, since we went over, let's make it just a little bit longer and be back at 11:20. Welcome back, everyone. Thank you for your patience during our break. As indicated just before the break, we have, first of all, a question from Commissioner Taylor, followed by Commissioner Yee.
Good morning, Professor Levitt. Again, thank you.
Good morning.
In your advice, you say start early, time to try different combinations, and you also say consider blocks of minority groups. Can you further expand upon that? And I guess, can you speak as to what's the relationship when you have a district that has multiple groups that might fall under VRA criteria?
So it's a great question, and one where I think, unfortunately, your predecessors left themselves too little time to consider real possibilities in this respect. Data came too late for them to really evaluate. The obligations under the Voting Rights Act, this is very much of a pattern with everything we've discussed before, are relentlessly driven by local data. So there will be some instances where different minority groups have very different political preferences. And there may be instances where each of those groups is sufficiently sizable or sufficiently compact to merit protection on its own. There may be other circumstances where different minority groups have very different political preferences, but only some of those groups are sufficiently sizable or sufficiently compact to merit VRA obligations. Right? Again, you can consider race and ethnicity beyond what the Voting Rights Act requires, if you wish. And there may be other circumstances still where data on the ground show that some minority groups have similar political preferences, and that you can effectively treat members of those groups for Voting Rights Act purposes as one coordinated voting bloc if the data show that they perform as a coordinated voting bloc. So there may be instances where, for example, African American and Latino voters have very similar political preferences, distinct from the rest of the voters in a community. And in that circumstance, if the data actually show that's a thing, you can't ever assume it, but if the data show that's a thing, then you might have an obligation to draw districts to give that combined group, to give African Americans and Latinos together, the reliable opportunity to elect the candidates of their choice. And their choice would be, the data would show, collectively very similar. If the data don't show that, then you can always consider coalition districts like that beyond the Voting Rights Act, but the Voting Rights Act wouldn't impose the same obligation. So it really depends on how members of different minority groups tend to vote. And that's shown by the same sort of polarization analysis that you do for any one minority group on its own. Does that answer the question?
Thank you.
Commissioner Yee.
Thank you. We still appreciate your time and help, Professor Levitt. You've been so magnificently generous and forthcoming, and we really appreciate it. So I have a question about defining minority group. The VRA language talks about race or color or membership in a language minority group. So one specific question and a more general question. The specific question is how to apply that with the census categories. So census, of course, divides Hispanic Latino out as an ethnicity versus the other categories of race. So how do those get applied in the VRA situation? And then the more general question is how straightforwardly are these categories applied in the past? If another group comes along and outside these specific categories, would we consider that, and so forth? Yep.
So you're absolutely right. These, for better or worse, the racial and ethnic groups are defined in the statute. It's not merely a free-floating determination. So the statute talks about, exactly as Commissioner Yee mentioned, race, color, or language minority group. There's a separate portion of the statute that defines what language minority group means for Voting Rights Act purposes. And it includes, and I'm quoting here, persons who are American Indian, Asian American, Alaskan Natives, or of Spanish heritage, Latinos or Hispanics. The Voting Rights Act does not itself provide obligations for members of other language minority groups. Again, you can always decide to do so if you wish, over and above what the Voting Rights Act requires. But those are the obligations that the Voting Rights Act imposes. How do you deal with census categories? So the Department of Justice has been remarkably consistent in this since individuals first began to, since the census allowed people to designate their own racial or ethnic identities in 2000, and in fact to designate more than one in 2000. The department has said, you essentially consider the data that will arrive will reflect this, by the way. So some of this is done for you in the data that arrives. You consider each racial or ethnic group on their own. Somebody who might identify as more than one racial or ethnic group will count essentially for both, because they may experience, the rationale is they may experience discrimination as a member of either group. So somebody who checks off that they are both Black and white might experience discrimination, depending on the circumstances, as either. Somebody who checks off both Black and Latino might experience discrimination as either or as the combination of both. So when the data arrive, you would see those people represented the way that the data come from the Census Bureau to you. Will probably be individuals who identify as Black or Black and another race. Individuals who identify as Asian or Asian and another race, all in one collapsed category. And then separately from that, individuals who identify as Latino, because Latino is presented on the census not as a racial group, but as an ethnicity or as a language minority group, that will itself mean Latino and or another race, right? That will include in it, because it will include everybody who checks off the Latino box. And then people who identify the census will usually back out people who identify only as non-Hispanic white and not members of and another race, so those who are the way that you use those data are you look for, first, let's consider, imagine that the voting patterns are all distinct. You would look to see whether there's cohesion within the racial group and cohesion in other members of the majority. So you'd look for political cohesion among those who are Black alone or in combination with others. And you look for political cohesion among those who are Asian American alone or in combination with others. It may well be that the data show that there's not political cohesion within a group, in part because, for Voting Rights Act purposes, in part because the census categories are too big, essentially. So for example, Asian Americans may have very different political preferences in the different parts of the state. And so you may find that Asian American alone or in combination, if you look to those voters, don't have a distinct political preference where Chinese Americans might, or Vietnamese Americans might, or other particular sub-ethnicities might. That would mean generally, I believe, that you could choose to acknowledge the communities of interest within the Asian American racial or ethnic or language minority group, but that the Voting Rights Act would not include that group as a distinct protected minority for polarization purposes if the data show that there's so much difference within that group that they don't have distinct political preferences for purposes of drawing a distinct district. I will say, I don't know that it's been tested when a redistricting group has chosen to draw districts on the basis of the Voting Rights Act. For example, Chinese Americans, when there is clear polarization in the Chinese American community from everybody, but not within the Asian American community writ large. And I'm obviously making all of these examples up just for demonstration purposes. So I don't know that that assessment that there would be no Voting Rights Act obligation if there's enough diversity within Asian Americans to show a lack of polarization among Asian Americans, even if there's polarization in subgroups. I don't know that it's ever been tested that a group decided to draw a district based on that subgroup. To be safest, I would always encourage you, always, if you are inclined to draw those districts, to consider other factors as well. And then to rest your reliance not purely on the Voting Rights Act, but on other communities. But that's something that the courts, that I am not familiar with the courts having tested.
I could follow up. Specifically, the census, ends up with a lot of Latino, Hispanic by ethnicity. They end up marking other, right, for race. It's been an ongoing issue. How has that been handled?
Yeah, that is an ongoing issue. There are several different problems with the data collection. I'll say, including Middle Eastern and North African individuals, including Latinos who mark down race of other. If the community is consistent, then what you'll see is a local group of other that also writes down Latino or Hispanic. And so you'll recognize them as Latino or Hispanic individuals. If they don't also check the box on Latino or Hispanic, that they mark themselves as other without designating Latino or Hispanic as a separate ethnicity, you won't necessarily have the census data to support their presence in the community, but you may know from the community that they're there. That would be another instance in where the legally safest course is not necessarily to rely on the Voting Rights Act, for which the census data is really the gold standard, but to otherwise embrace the community that you see located locally that isn't reflected necessarily in the empirical data you get. Or I shouldn't say that. that isn't reflected in one type of empirical data. Data from the community, hey, we're here, we just weren't included in the census, is empirical data. It's just not the same sort of data. So I think the legally safest approach might very well be to acknowledge that, but not necessarily in reliance on the Voting Rights Act as the source. But there too, I don't know that that's been litigated. I'm not familiar with a circumstance in which that's been litigated. And if you decided that you were going to rely on a large portion of voters categorized as other, who were not identified in the census as Latino, but where you know from your community outreach or from other sources of data as Latino, if you decided that you were going to base a Voting Rights Act district on that information, I think that's entirely defensible. It's just you'd want to make sure that that you were clear about what information you were using to make that finding. I don't know if that answered the question. Really good questions.
Yes, thank you.
Okay.
I'm sorry to interrupt, Chair. This is Christian. We have a caller, and I'm not sure if it's one of the commissioners. If, with your permission, I'll allow them to talk, and we can double check.
Go ahead.
Oh, they're gone now. I'm sorry. We'll keep an eye out for them.
I scared them away.
Okay. Commissioner Sinai, then Commissioner Anderson, and Commissioner Sadwani.
If, as we're thinking about the VRA, and what I keep hearing is, you know, sometimes you need to go deeper, especially when it comes to the Asian community, because there is a lot of, diversity within it, and the same, like East County and San Diego, you may get a lot of white, but the white is really Middle Eastern, and so there's little nuances. If we identify things like that, I guess I'm thinking about targeting our outreach in those specific areas to collect, the communities of interest information. If we were to do something like that, is that race leading us? I mean, is it okay? Is it advised? Is it?
Yeah, that's a great question. So the only prohibition on the improper use of race is in whether you put a sizable group of people inside or outside a district, whether you're drawing the district line to include or exclude based predominantly on race. And again, that's okay if there's a really good reason. I don't want to say that's out of bounds entirely, but that only comes into play based on where you put the district lines. Your decisions to do outreach, your decisions to do investigation, your decisions to collect facts, I don't think there's any prohibition on your understanding that there are groups of particular races or ethnicities that you want to get extra input from. It is totally fine. I can't think of a reason why that would be improper under the law as I understand it.
Okay. Commissioner Anderson?
First of all, thank you very much for the presentation. You always take sort of dense topics and make them just so accessible and easy. I really appreciate it. I have two questions. The first one's kind of a quick, easy one. The second one is more involved. The initial question of size of a group, what's the ballpark?
So the ballpark is going to be the average population plus or minus. So you know that the size of your district is going to be roughly the average population plus or minus 5% bigger, 5% smaller, right?
Yeah.
Ish, in order to stay within constitutional bounds.
Mm-hmm.
And so when you're considering whether a group is 50% of the electorate in a district-sized population,
okay,
that district-sized population will range plus or minus about 5%-ish. That's approximate, because for a good reason, you can go over or go under, but that's a good target to start with, that you're looking for a district-sized population about in a range from about 5% over the average district size to 5% under. And the average is just driven by the number of people in the state and the number of districts you're drawing. So it's going to be a different measure for the Assembly, for the Senate, and for Congress, and for the Board of Equalization.
But in terms of like a racial group, the racial group then needs to be about 50% plus or minus. And
The
then
electorate needs to be. So there are two different things, and that is complicated. You're looking for a district-sized population, total population, and you want to know that the racial group or groups that you're evaluating are at least 50% of the citizen voting age population within that total district size. So you're not just looking for 50% of a total population, you're looking for 50% of the electorate there, and that may be different.
Right. Okay. Thank you. The second question is, obviously California has a huge plurality of races. And because of that, could you address the 2013 change in the Voter Rights Act, in that specifically for California, it's changed the rigidity. You don't have to do certain things, but and a lot of states that's obviously really going to adversely affect minorities. In California, that loss of rigidity might help us stay with the intent without the rigidity. And could you explain sort of what actually happened? Particularly because when we're going to go back, we don't want to be looking at rules we don't need to follow.
Right.
And then how we could work with that, please.
Sure. So I will try to make this short. I also will try to make this not confusing, because now we're talking, as Commissioner Anderson recognized, about something you don't have to do. So before 2013, and still technically, if Congress ever gets around to applying a different formula, maybe in the future, but not right now. In some areas, including parts of California, in addition to all the responsibilities I talked about so far, there was a separate part of the statute that essentially said, if you have racial communities with certain levels of political power, no backsliding. So this was because of a particularly troubling history. It said once you'd reached a certain level of political power, you can't take that power away. You can't backslide. You can't make things worse for the minority community there, period. This is another portion of advice that I don't know that I agree with from counsel from 10 years ago. That was always meant to be a functional evaluation and not based on specific demographic percentages. So that wasn't a prohibition. To put it differently and in your terms, I think that was less rigid than it was sometimes interpreted to be. So I don't interpret that backsliding as a limitation that said if a group now constitutes 57% of a district, that it could never in the future constitute 56.8% or 0.7% or 55% of a district, if that meant functionally the same level of political power. If the group had an opportunity to elect with 57% and still had an opportunity to elect that was reasonably the same with 54%, that sort of change in demographics was, I think, fine. Some legislatures, some commissions, I think last time the guidance was a little bit ambiguous from council on this, said whenever you've got a certain percentage, you have to peg at that percentage and go no lower. And I think that was a misinterpretation of what the statute required. The statute said no functional backsliding rather than no demographic percentage point backsliding. And so I think to the extent there was rigidity in the last cycle that may have been artificially imposed, to the extent there are now groups with functional levels of political power, there's no legal mandate to maintain them in the abstract. But where those groups have the opportunity to elect candidates of their choice, there may still be an obligation to provide those same groups with opportunities to elect the candidates of their choice. The data will show whether that's still an obligation or not. But in many places, voting that was polarized will remain polarized on the basis of race, unfortunately. And in many places, that means where there was a functional level of ability to elect candidates, you may still have to provide that opportunity to elect under the section of the Voting Rights Act you do have to apply, regardless of the disappearance of this other one. That is, I think the biggest change for you all is a procedural change and not a substantive one. The part of the Voting Rights Act that no longer applies required that you run stuff by the Department of Justice or by a federal court before it could take effect. That was a measure designed to stop discrimination before it started. And so entities across the country, including California, had to pre-clear maps with the Department of Justice or with a federal court before they could take effect. And that chunk of time that it took for pre-clearance meant that you had to leave room at the end of your process for the Department of Justice to run stuff by before you could have candidates file for primaries and the like. That no longer applies in California. So you no longer have to leave extra room for a Department of Justice procedure at the end of the day. I suspect that will be the more meaningful impact for you all on the absence of this one part of the Voting Rights Act this time, and not necessarily the substance, if that makes sense. That there's so much more there, and I want to make sure that I'm answering the question without going too deeply down the rabbit hole.
My understanding was also it did lock in certain counties. You had no flexibility in that, and that's sort of the other part I was really kind of hoping you might address as well.
Yes, sorry, that's a good point. So this part of the Voting Rights Act applied only in certain jurisdictions, and there were 4 counties in California that had this special obligation. That meant essentially that the commission had to start in those 4 counties to make sure that they lived up to this part really firmly. To the extent there are minority communities in those counties, my hunch, to be examined by the data, but my hunch is that voting is still likely to be polarized there, and there are still obligations that you may have in those areas. So I don't think you'll be able to ignore those counties. Not that I'm suggesting you were going to do that. I think you will have to treat them with similar care as in 2010. It just means that you won't necessarily have to start there and there alone. But they may still be worthy of your focus, in part because the fact that they had obligations under that other section of the Voting Rights Act, number one, it shows you've already got a pretty clear history of discrimination there. That saves you a little bit of data gathering. The Congress and the Justice Department decided that there was already a history of discrimination there. And to the extent there are minority communities in those areas, if voting's still polarized there, you're still going to have obligations under the part of the statute that does apply. So it takes a little bit of procedural rigidity out, but I don't think it changes your approach much in terms of the substance.
Great, thank you. It's just also with it allows the accounting for migration. We've had a lot of that sort of thing, which is where I'm sort of the multi-tiered thought there. So thank you very much for the question, for the answer.
Yeah, and that I should emphasize. It may be that the communities in those areas still are polarized and still are sizable and still, but all of that is subject to what do the data actually show. So California has had migration all over the place, different growth rates in different communities. So there may well be places in the state where you have obligations now that you didn't have in 2010. There may well be places in the state where you no longer have obligations that you had in 2010. And there may be places where you have very similar obligations to what you had in 2010.
Very good. Commissioner Sadwani and then Commissioner Turner.
So much, Professor Levitt, because as always, this is so helpful. And I think I echo Commissioner Anderson and others. You have a way of explaining things that is precise and very clear, which I think is extraordinarily helpful. I also anticipate that we have an infinite number of questions regarding the VRA and what compliance will look like. Before you came on, Commissioner Yee and I had presented a number of recommendations to the Commission. And I'm wondering if we could center some of our conversation around some of those recommendations and specifically get your feedback on those so that we can move forward, begin some of the analysis that you have, even suggested that we should start with, as well as move forward with our process to identify VRA counsel who could answer these questions for us in the future at every single meeting. So to that end, I wanted to get your thoughts on two pieces. First, one of our recommendations, one of the pieces that the commission needs to consider is that the subcommittee has discussed with you previously, are the pros and cons of keeping RPV analysis either public or as attorney work product or under attorney-client privilege. The answer to that question will determine how we hire an RPV analyst because of all of the various state procedures for hiring these kinds of individuals. So I'm wondering if you could walk us through that. Our recommendation to the commission has been, taken from our conversation with you as well as with others, has been to instruct our chief counsel to move forward with hiring an RPV analyst at this point in time who could begin a public-facing analysis kind of at the statewide level to craft an overview of racially polarized voting in California. And also I'm thinking, as you're showing these beautiful heat maps, to also provide some of that assessment using ACS data to inform our process moving forward. We have also advised the commission to consider whether or not to keep additional analysis, that more localized analysis, under attorney-client privilege. And I'm wondering if that's something that you could speak to and help us understand the pros and cons. We, of course, all value transparency in this process, but as it relates to potential future litigation, what might we need to know about the pros and cons of releasing that information?
Sure. And I will attempt as best I can to lay out the pros and cons for you without any role as an advocate for one end result or another. So this is essentially a choice about the degree to which you want to be transparent versus the degree to which you want to incur litigation risk. And there's not a wrong answer to that choice. There are different answers. There may be different answers based on your preferences, but there's not a wrong answer to that choice. So when the lawsuits come, those who are planning to attack the work of the commission will use every tool at their disposal to attack the work of the commission, whether the commission's work on that particular subject has anything to do with their complaint or not. So you may see someone suing you on Voting Rights Act grounds or other grounds, even if their complaint has absolutely nothing to do with the Voting Rights Act, really. They're just trying to get a different map in place that they prefer for other reasons. Or you might see somebody suing you because their complaint is actually based on the Voting Rights Act. The data that you provide are one source of that potential attack. So those who are unhappy with your work will claim, if there is a district that you draw based on the Voting Rights Act, that there was no reason for you to draw that district based on the Voting Rights Act, and that you drew predominantly based on race, just like happened in Virginia. And so if there's a group that's critiquing you for drawing a particular district, ostensibly on Voting Rights Act grounds, then they'll come after the choices that you made about which people to put inside or outside the district, the same as those sort of maps that I showed highlighting where African-American voters were in District 95 in Virginia. But they will also come after the basis for your assessments of Voting Rights Act need, like racially polarized voting analysis. And just as you will be hiring a VRA analyst who's an expert in doing this work, somebody who would be critiquing it would be hiring a VRA analyst who is an expert in racially polarized voting analysis to say, no, what you heard from your expert is not actually right. This group isn't polarized or isn't sufficiently polarized because of X or Y. We've mentioned before that you want to choose a selection of races, of particular candidacies, of particular elections, that you don't ever want to rely on just one. And so the challenge will come, they chose the wrong bucket of races. There was something weird about this race they shouldn't have included. They should have included other races in the mix. So if you make that data public, not only will challengers have information or data of their own, they'll have yours to attack. And if you don't draw districts on Voting Rights Act grounds and somebody asserts that you should have, if you make your analysis public, the same attack will come. They showed no polarization in X or Y area. They really should have found polarization because you chose the wrong races, you did the wrong analysis because there was something flawed in what you did. So there's risk to putting that localized information out there in the world. There's also a transparency boost to putting that information out there in the world so that you can say, look, the reason we drew this district was in part based on the Voting Rights Act because we showed there was polarization there. Look, here it is, you can see. Or the reason we didn't draw this district is because we found there was no polarization here, even though the community is large. Here's the analysis, look, you see. So that the decision of what ultimately to do is ultimately a preference for which of those values you think speaks more strongly to you in the particular instance. Those are the basic pros and cons of either releasing the information or of holding it tight.
Commissioner Sangwani.
Thank you. That was much more eloquently put than I ever could myself, and much more informed. So thank you. And I think I just want to also stress for the commissioners that what we decide today does not have to necessarily be our final choice. You know, the recommendation that we are giving to the commission is to move forward in hiring someone who can start this now, the overview. When we have VRA council, they too may have someone different. They might want the same analyst. We don't know that yet. And so we didn't want to tie our hands necessarily to one and only analyst for racially polarized voting assessments. And so therefore we do have a little bit of time, but it's something that definitely has to be on our radar. And I would also stress that to the extent that we can, that the subcommittee and more importantly, that our council can be given that authority today to move forward with hiring an RPV analyst to do that top level analysis that would be public facing would be really important. And as we move forward, we can further decide whether or not we want to make the more localized analysis public.
I'd just like to add something very quickly to that analysis, and then that is a limit on what I'm telling you here today. I am not a Brown Act specialist and certainly don't want to suggest anything other than what your general counsel tells you about the extent to which your information can or can't be public more generally, or the extent to which part of the information you make more public may lead to other bits being more public. So I just want to frame all of that very carefully in a caveat. You should take your counsel's recommendation on how your decision here generally affects what you may have the obligation to release or not. They will guide you, and you should not. The pros and cons that I laid out may have important asterisks or caveats based on what they tell you about information that you have the obligation to release or not. So follow their guidance over mine in that respect. In all respects, but also in that respect.
Commissioner Sangwani.
Thank you. And just to add also, there's so many components here. I think what we have arrived at in our many conversations, if we end up going the route of putting out a request for proposals for an RPV analyst, excuse me, we might ultimately have to make that work product public. And so then we are tying our hands to that decision. Whereas if our general counsel were to hire that person, for example, through an interagency agreement or some other form, then we would have more choice in that matter. And that's my understanding of the the state procedures. So if I'm misspeaking, you know, Mr. Claypool or Marion or Ms. Marshall, please feel free to correct me. But that was my understanding and what we were using to develop these recommendations to allow us the greatest amount of flexibility on this piece.
Commissioner Anderson?
Thank you. One quick question. You know, we're sometimes not to get caught up in names, because when we're for proposals and scopes of work, we're talking about a litigation counsel who would be, you know, from obviously once again it's litigation, and a VRA counsel, a VRA analyst, and an RPV analyst. Could we have our VRA analyst, maybe if it is or is not completely client attorney privilege, but if our VRA counsel, VRA analyst is the same, then we have the opportunity of opening up what we'd like to the public or not, because it's of counsel. So is that, and this is a bit more, one, to check terminology and things with Justin Levitt. Also, Marion, the state agency agreements, are those also, I mean, attorney-client privilege is an easy one.
Contracts are always public.
State agency is always
Contracts are always public, yeah.
The contract, yes, but the work product.
No, the work product can be, if it's done on the request of an attorney, it's protected as work product.
And what if it's on the state, is the state agency agreement, if it's through an attorney, then it's... If
the analyst reports to the attorney based on what the attorney wants the analyst to do, then it's attorney work product, which is not absolutely privileged, but it's protected.
Thank you. Mr. Levitt, do you have any,
Oh, no, in that regard, I'll defer entirely to Marion. The way in which you structure that arrangement has far more to do with the rules that govern you in your responsibilities as a public commission than they do about the Voting Rights Act. So,
okay,
I'll leave that to her.
In terms of having the VRA counsel and VRA analyst at the same person, different person, what are maybe pros and cons on that?
I think you want them to be on the same page, but I don't know that they have to be the same person. So they want to have the same understanding of what the data are actually showing, of where you might have an obligation or not. And so you want them to be aligned and able to work together if they're not actually the same individual. But I don't know that they have to be the same person.
Commissioner Sinai, did you have your hand up?
Yeah, and this might be a little in the weeds, so I apologize, but the stuff that we said, I'm still trying to figure out the pros and cons of making it private or not, or public. And when we go to draw the lines and we present our maps, we're supposed to give reasons for every single line we draw. And so how would we give a reason if that data is private?
So my understanding, and here too, I'm going to defer to both Marion and Dan and others, is that you can say we drew this district in order to comply with the Voting Rights Act and for other reasons, including the following things, without necessarily releasing all of the underlying data or information that you use to make that conclusion. Or you could decide to release some or all of that underlying data, I believe, but I think that's up to you.
And I agree with that.
Director Claypool, did you have your hand up?
I did. I just wanted to say that I remember the reports that went with the maps from the last one, and it might be well worth it for you to read them. They were very brief, and they were in many cases non-specific about exactly why things were done. So you have a lot of latitude.
Thank you. Commissioner Fernandez.
So let's say we don't disclose the data when we write the reports. Is that data, however, discoverable once it goes to litigation?
It might be.
That's a very maybe. Okay.
Attorney work product may be discoverable if it becomes relevant in litigation.
Anyone else? Okay, well,
I think you've got Commissioner Vasquez.
Commissioner Vasquez.
Yeah, yet to find a background that doesn't make my hand disappear into the ether. This might be a dumb / basic question that has already been answered, and I apologize. I've missed some of the Q&A. But if we make a choice to not disclose the data, but we are discussing and drawing many of these, drawing all of the lines sort of in public and having discussions about, what are the impacts of moving a line here versus here. In those discussions, we will be discussing the data as part of our sort of thinking on why we want a line here versus why we want a line here. So I'm a little confused about sort of how much of that is already public via our conversations anyway.
Your reason could be based on advice from your VRA consultant. If you actually discuss the content of the document in public session, then under Bagley-Keene it becomes public. But you don't need to discuss the document itself.
So follow-up question. So then we could theoretically even have the data sort of in front of us privately viewing, but in the discussion say, based on the data, I think it should be here.
I'm not sure. I think last time the nuts and bolts of the analysis was not given to the entire commission. It was given the overview, the broad conclusions that were reached by the analyst.
And just to clarify, so for example, if I can share my screen for another 30 seconds and only that. Where did you go? My apologies. I can't seem to do it. If you remember the chart of the racially polarized voting of all of the circles in the line, there are lots of those that combine to give you an assessment of whether voting is racially polarized or not in a particular community, and also the extent to which it may be racially polarized in a particular community. And all of those add up to, and this therefore is the level at which we feel comfortable that a particular racial group that is polarized would have a real equitable opportunity. And I think you can decide how much of that back down the chain you want to make public. So it's a little bit like raw data, and then analysis of the raw data, and then analysis of the analysis, and then a conclusion. And I think you can decide at which point you want to make any of that public versus at which point you would rather retain it for yourself. You can still act on the conclusion if you decide to keep the underlying data private.
Okay. Commissioner Fernandez and then Commissioner Sadwani.
And maybe I misunderstood this when Commissioner Sadwani was presenting it, but some of the discussion around the data may be in closed session, or was I mistaken with that? Or we don't know yet.
It could be. I can't be more specific than that. It depends. If you know there is a real risk of litigation and you want to avoid presenting that information to the world, then it could be in closed session.
So then at that point, and this is just addressing Commissioner Vasquez's question, if it's something that we discuss in closed session, then we would not necessarily, we could choose not to put it in the report. Does that make sense?
Well, what would go into the report is it based on VRA analysis.
Mm-hmm. Right.
Commissioner Sadwani.
So just to keep us moving and not to stop discussion, but I also see that callers are starting to call in. I'm wondering how we feel about if I were to make a motion to instruct our council to move forward with an interagency agreement to hire an RPV analyst at this time, specifically for that outward facing initial assessment. That may or may not be the same person that we ultimately use for the more localized analysis, but at least so that we can get started with a broader outward facing process that we would make public, that would be more statewide in nature and would create some of these maps for us to identify regions where we might want to focus more. That would be that first motion. Well, that's a very long version of it, but that would be the content of that first motion. Separately, we can think about the statement of works for VRA counsel, outside litigation counsel. Whomever we hire for VRA counsel might have their own RPV analyst that they would want, right? We don't know that. They might have different recommendations on whether or not to keep this analysis public or private. So that's why I'm putting forth a motion specifically for this first stage of analysis and to empower our council to just move forward with an interagency agreement to start that process for us. And I suppose Marion and Ms. Marshall, if I need to solidify that more, I most certainly can, but I wanted to explain it.
Two things. One, you need a second, and two, it would be a special vote requiring the 3, 3, and 3.
I second it.
I'm sorry, who was that?
Okay, Commissioner Fornashari and then Commissioner Yee.
And Fernandez.
Commissioner Fernandez was before me.
You have to raise it a little higher because I'm just seeing your name.
I'm just pale all over the place. It's pale walls, pale face. It's just pale. Anyway, I just wanted to confirm whether or not, I mean, we're going to make this motion. Have we brought in our chief counsel into this conversation? If Commissioner Sadwani and Yee, I just want to make sure that we're not doing something that maybe she's also looking at something else. So.
She's not here right now. I don't know.
Oh, sorry. Go ahead. We haven't had that chance to have that conversation with her. We were working on this and developed all of this as of Thursday of last week. I don't know what her first start date is, but I know Commissioner Yee also had sent an email kind of laying out some of our recommendations, and that we hope to have that conversation very soon. I don't know. There's not a camera on Miss Marshall, so I'm not sure if she's there, but please feel free to weigh in.
We're going to meet together on Friday.
I'm sorry?
We're meeting her on Friday.
Okay. I have next Commissioner Fornashari, then Commissioner Yee, and Commissioner Akutagawa. Did I miss anyone? Commissioner Turner.
Director Claypool, I think, is also a hand up.
Thank you.
Okay, so Commissioner Sadwani, maybe I just missed it, but can you kind of clarify, is kind of be a little more specific, is what is the deliverable, what's the outcome from this higher level analysis?
To better inform our process and to produce one public-facing document about racially polarized voting in California. I think some of the well, there's only been a very small amount of criticism about not releasing the information from 2010. I think only one individual has shared that concern. To me, it's about giving us information about how we might want to structure our process early on, as well as kind of offering a good faith effort of transparency, right? And I think the commission has never received public feedback about racially polarized voting analysis. So with such a document, what is the kind of feedback that we might get? Perhaps that could help inform our later decision about whether or not to release that information. That's kind of my thought process in any case about why to start here. And also it allows us to get started now. One of the things is if we went forward and put out an RFP for this analyst, it's going to take quite a long time, right? So we could have some of this analysis before we even hire a VRA attorney, right? VRA counsel. So there's the time element, but it also ties our hands that the analysis would most likely have to be public, right? It's the commission asking for that work rather than an attorney asking for it. And I don't know that we're prepared to make that decision today. And that's why I've made this recommendation that we get started with the analysis, that the initial analysis would be public facing, and that we can then move into a secondary stage in which we can make decisions about the more localized analysis. Does that help?
So the outcome is going to be a report. Okay.
Hiring and a report.
Yeah. Okay. I didn't know if we were going to get a map or we're going to get I didn't know what to expect out of the analysis. Okay. Thank you.
Very good. Commissioner Yee?
Yes, Chair, recommendation, respecting Professor Levitt's time, I'm wondering if we could go to public comment and then for any questions he might be directed to him, and then continue considering the motion after his time with us.
Okay. Marion, on that, if we take public comment now, is that going to be sufficient for the vote?
Yes.
Okay. Then I would ask Commissioner Akutagawa, Commissioner Turner, and Director Claypool. Well, Director Claypool, is yours immediate?
It is.
Please.
It is, in short. So to clarify, you are asking us to actually draft the interagency agreement so that we can work with the RPV expert, develop what we're going to present, and then we will come back with that draft for finalization. Am I correct? So we are going to develop the costs and everything else first. Perfect. Thank you.
Okay. Commissioner Turner?
Yeah, the clarification I wanted on the proposal from Commissioner Sadwani as to the questions about council being present or not was that it was just a proposal that also included determining if our council is in agreement that this is the way that we should go, right? I think I heard you say that in there. So council could come back and say that this is not my recommendation. I don't want. So I just wanted to name that because when you said it, I thought, well, this is great. This does free her to be able to move forward in whichever manner.
Okay. Let's go ahead and, okay. We do have 3 callers in line. Katie, can you go ahead and read the instructions for others? And I will get back to commissioners with hands raised.
Yes, Chair. In order to maximize transparency and public participation in our process, the commissioners will be taking public comment by phone. To call in, dial the telephone number provided on the live stream feed. The telephone number is 877-853-5247. When prompted, enter the meeting ID number provided on the live stream feed. It is 915 0553-2099 for this week's meeting. When prompted to enter a participant ID, simply press the pound key. Once you have dialed in, you will be placed in a queue from which a moderator will begin unmuting callers to submit their comment. You will also hear an automatic message to press star 9. Please do this to raise your hand, indicating you wish to comment. When it is your turn to speak, the moderator will unmute you and you will hear an automatic message that says the host would like you to talk. Press star 6 to speak. Please make sure to mute your computer or live stream audio to prevent any feedback or distortion during your call. Once you are waiting in the queue, be alert for when it is your turn to speak, and again, please turn down the live stream volume. These instructions are also located on the website. The Commission is taking public comment on the motion in regards to hiring a VRA analyst made by Commissioner Sadwani. And we have 3. I will start here. Please press star 6 if I have... Oh, yes. Oh, no. Shoot. Please state and spell your name. Caller 051...
Hi, this is...
Could you state and spell your name, please?
Yes, this is Lori Schellenberger.
Okay.
Lori. Last name Schellenberger, Schellenberger. I'm the redistricting consultant for Common Cause. And I'm actually calling in, I want to actually, and perhaps Marion can answer this, is I was calling in to speak regarding the RFI and Statement of Work for the Voting Rights Council, and I wasn't sure when you would get to that topic. And I wanted to present those questions while Justin was still there, but I also understand this is to speak on the motion at hand. So is it appropriate for me to offer comment on the RFI for the VRA Council?
I think since that's part of the discussion that led up to that, that would be fine.
Okay. All right. Thank you. And good morning to the commissioners. I think I was the last one to call in yesterday. I'm the first one to call in today. And I really appreciate I can't say enough how much we appreciate the thought and that's gone into the various documents produced by the VRA subcommittee and the thinking they've done and the outreach they've done. And also always enjoy hearing Justin Levitt speak about the Voting Rights Act. I just wanted to raise a few items related to the RFI, and I'm actually submitting these comments on behalf of myself and on behalf of NALEO Education Fund, Rosalind Gold. And I discussed these at length, and she could not call in right now because she's actually conducting a redistricting training for her staff at this time. So I have 3 comments and 1 general comment. The first is regarding what is a redistricting activity, and we would suggest that you define that at the beginning of the RFI, and perhaps discuss how you want to define that. But in most of the places that it's listed, it seems to be referring to the work of the commission. So just make it clear it's not just line drawing, but also accessibility to hearings, evaluation of testimony, and et cetera. We just think it would be good to define that a little more clearly. I have a comment related to Section 5 and the second paragraph of Section 5 regarding expertise. And we would recommend that you change the word experience to expertise in that second sentence of that second paragraph, just because it's a little unclear what experience would mean. And do ask for more details about experience later in the RFI. So just suggesting you change experience to expertise in that second sentence. In addition, we'd recommend you strike Bagley-Keene. We don't think that you have general counsel and you have Marion Johnston at your disposal, and they're experts on Bagley-Keene, and that doesn't seem to be as important for the VRA Council. I have a recommendation regarding Section 5, and it's number 3 in Section 5. And it's really just a recommendation that you get rid of the reference to 2 specific cases, which we were a little curious about why you chose to include the Shaw and Miller cases in there in particular and highlight them. The Voting Rights Act, as you've just spent 2 hours discussing, has lots of complexity, and there are lots of lines of cases, and attaching special importance to some over others just may inadvertently signal things you don't want to do, and we don't think it's critical that you highlight any particular case over another. And then finally, on page 2 in section 6, item number 3 regarding experience, we would recommend that you expand that a bit at the beginning of that section to list all experience related to districting, redistricting, and election-related litigation potentially, because first of all, there is a difference between districting and redistricting, and because there are folks who have experience, and under Section 2 and Section 5, there's litigation that happens related to at-large and conversions that require initial districting. And secondly, related to election law, generally you have asked for experience with California Election Code and the Voters First Act, but it would be good to know if folks have experience litigating voting rights in other contexts besides the VRA, because there are instances where there can be litigation to expand or restrict voting rights that it isn't specifically under the Voting Rights Act. And we'd also suggest that you change significant to all, so you avoid someone cherry picking what they want to share. And if you do include all, maybe you only want to go back 20 years. Maybe if someone has 40 years of experience, you don't want every case they've ever been involved with. Finally, we would also suggest that on that list of experience, you include publications, because there are folks who have done significant amounts of writing, and that's not litigation related. So that concludes my comments. I'm sorry I went over time, and I'm happy to stay on if anyone has questions.
Ms. Schellenberger, just to make sure that we do have all of that, did you indicate that you would also be submitting it in writing?
I did not, but we can do that. Unfortunately, we didn't have a chance to connect until very early this morning with our feedback, and didn't have time to put that in writing, but we'll absolutely do that.
That would be helpful. Thank you so much.
All right, thank you.
Thank you.
Next caller, could you press *6? Thank you. Could please state and spell your name for the court reporter? You are live. Could you state and spell your name for the court reporter? Caller 2790. You are live. Or not. Okay. Next person. Oh, nope, they're back. Can you please state and spell your name? You are live. Can you talk, please? Okay. I will move on. Can you please... Caller 4557, press *6 to unmute. Please state and spell your name for the court reporter.
Megha Manohar.
Yes, you're live. Can you please state and spell your name for the court reporter?
Sure. My name is Megha Manohar. My first name is Megha. And my last name is Manohar.
Thank you. Will you please state your comment?
Sure. Good morning, everyone. My comment is about representation for the Asian community in Silicon Valley. As of 2019, there are 13 congressional representatives of Asian American descent who are currently serving. Many Silicon Valley cities have switched over to district elections under the threat of litigation, making it easier for minorities to be elected. would you consider redistricting to ensure that more Asian Americans will have a chance to be elected to Congress? For example, Congressional District 18 has never had a minority congressional representation, and Asian Americans are the largest minority community of this district. That's my comment. Thank you so much. Appreciate giving me the opportunity. Thank you.
And thank you for calling in.
The other two callers that we have in the queue, if you would like to make a comment, can you press *9 to signify that you would like to speak? Thank you. Thank you. If you'll press, please state and spell your name for the court reporter.
Steve Harnish.
Thank you. The floor is yours. Oh, go for it. Sorry.
Oh, Harnish, Harnisch. And I'm, thank you, commissioners. If you do direct the council to enter into an interagency agreement with UCLA to do this preliminary analysis, I think it's important that the agreement state that Mr. Barreto shall exclusively use the data provided by the statewide database. This is important because the purpose of the document is to be available to the public. So it's critical that it rely on data that is also available to the public. Prop 11 includes this requirement for an official publicly available redistricting database in the interest of transparency so any Californian can replicate and verify the commission's work. When Mr. Barreto presented in September, he proposed using his own racially polarized voting methodology, the BISG, and that would use individualized voter data, not part of the statewide database. Relying on proprietary methodology, using confidential voter records, it could certainly bias or at least limit your choices for future vendors. And as Professor Sadwani noted, you don't want to tie your hands at this point. Thank you for your consideration.
Thank you very much for your comment.
We have one more. If you'll press *6. Caller 3732, if you will press *6 to unmute yourself. If you'll press *6, it will unmute you. They do have their hand up. I can't unmute them unless they hit *6.
They may still be listening to the live stream.
Oh, there we go. If you'll state and spell your name, please.
Hi again, Deborah Howard, California Seniors Advocates League. Deborah, DeborahHoward. I had 3 comments, but now I have 4. And I want my first one, which was the one that I just added, is really we have to do better on technology. Being the last caller in the queue, I think I tried to unmute myself probably 14 times. There's better technology available, and that actually feeds into my other comments, which all follow under the category of, again, an issue that I've raised in the past, which is that the default position of the commission be being transparent. I understand about protecting yourself for litigation purposes, but the default position would be to share, and I think in the comments, to share with the public so we can contribute to the conversation meaningfully. And I think just before you went to public comment, there was a question about only one person has requested the former report from racially polarized voting that was done in 2010 by Professor VRA, let me be number two. I absolutely think that that should be made public now. It can no longer be relevant to litigation. And if we want communities to, again, contribute meaningfully, we need to know what it looks like. So I'll do that. And I did have a third thought, and that is that I understand that it's really hard to do this while you're building relationships with each other, trying to bring in the larger community of people who are interested, as well as those who will simply be affected by these districts that will be drawn over the next 10 years. But I think there is also a really good model that the Biden-Harris almost transition team is working, and that they're providing readouts of calls and conversations that they are having at a very high level. I think that's actually a really good model that is not onerous in sharing the information, but also creates a record that tracks the pathway that you're taking to make these decisions. And I apologize for my frustration at the beginning. It is really hard to listen to the live feed, which in my circumstance is delayed, I don't know, I'm going to say close to a minute, and being able to track, being able to call in and make these comments. It's not about me being comfortable, but it is about you all being able to get legitimate feedback. So I echo everything that has been said. These are hard conversations. You're approaching them with intelligence and deep consideration. And for that, I am thankful and appreciate the opportunity to comment. And again, emphasize default to transparency and share the past work on racially polarized voting that was presented to the 2010 Commission. Thank you.
Thank you, Ms. Howard. Katie, are there any others in queue?
No, there are not.
Okay, so I have Commissioner Anderson as in queue for comment.
This is back to the getting the council to basically essentially the RPV analyst. And you're saying, okay, the outward document, based on what? This is the whole state. I mean, what's the scope?
Or may I respond?
Yes. Well, please.
The thought is that that the analysis could be done looking at statewide elections as opposed to the localized elections.
But you're looking at the entire state as one general, looking at statewide elections in each area. Is that correct? It's not just, I mean, is it basically data on the entire state or on certain areas?
It could be based on certain areas, but how they're voting in statewide elections as opposed to localized elections, if that makes sense.
Right, but are we asking for this report to cover areas of the entire state or just specific areas?
My sense is that we could ask the analyst to help us determine that. My sense is that we can take the ACS data, as was suggested actually by Professor Levitt, to do those types of mapping, to identify those areas where we find populations that would be covered by the VRA, and begin that analysis, but using statewide elections, as opposed to more localized elections where we get into, all sorts of variations in terms of the candidates that are available, et cetera.
Okay, so just to clarify then, so you're saying we're essentially looking at the entire state, roughly, but based on statewide election to give us, these are the areas that we'll probably have to address, and roughly addressing those. And then the next stage would be actually looking at the local elections on those particular areas.
That's correct.
Okay, got it. Thank you.
Commissioner Taylor.
Yes, I think I would like to hear from Justin and Miriam as it relates to the statement by Mr. Harness, in that we should use information that is accessible to everyone and not specifically a private methodology to come up with the analysis.
So I can speak to the limits of what census data may provide. I'm going to let Marian speak to the obligations that you may have about the data that you draw on, if that's okay, Marian. The census data may be quite accurate for some purposes and less accurate for others, depending on problems that the census itself has in measurement. We don't yet know exactly how good the census data will be in every part of California. Some other information can be used to supplement the information you get from the census in order to confirm accuracy, in order to raise questions about accuracy, or in order to more finely tune the polarization analysis that you get. So, for example, the Department of Justice recently used a method that Mr. Harnish actually mentioned called BISG analysis, Bayesian inference statistical. I don't know what the G stands for. I've forgotten. Commissioner Sadwani is going to illuminate. The Department of Justice used this, by the way, in overlapping administration. So it's not a particularly politicized method of evaluation. It's a statistical method that essentially means, in addition to, or rather than, looking at information top down in a precinct to determine which voters of which races or ethnicities preferred which candidates. You look at the information bottom up by evaluating the likely racial or ethnic identity of individual voters. So one way to approach, if you recall, in any polarization analysis, the circles that you have represent the precinct and the racial composition of the voters within the precinct. One way to do that is to look at the census-based breakdown of the racial or ethnic identity of all of the people within that precinct and assume that the voters mirror all of the people within the precinct. So if the precinct is 55% Black voting age population, then you would assume that the voters in the precinct are 55% Black. A supplemental source of data looks bottom up. It says, here are the actual voters. Based on what we know about their likely ethnicities, does that confirm that the voters in this precinct, the people who actually cast ballots, which is public information, just comes from a different source. The voters who actually cast ballots, not who they voted for, that's not public, but their names and the fact that they voted are public. And there are reliable, again, Department of Justice approved, court approved, statistical techniques to evaluate if we know the following 400 people voted, here is their likely racial and ethnic composition. Rather than guessing of those 400 people from the 1,000 people who live within the precinct area, we can try and estimate based on the identities of the actual 400 people who voted. Often, those two sources of information, one taking from a broader assessment of the precinct demographics and one taking from the actual voter rolls, match. And so they just confirm each other. Yes, we think that shows that the overall assumptions we were making from the census data are correct. Sometimes they don't, and one may be, it may be easier to see one's more reliable than another. So, and in some cases, for example, in the Department of Justice instance that I'm mentioning, the location was small enough. It was a case in East Point, Michigan. There aren't that many people who live in East Point. The census estimates weren't that precise. And so the more accurate information actually came from examining the voter rolls. There was a wide margin of error in the information that came from the census, a much smaller margin of error that came from the actual voter rolls, and that allowed for more precise analysis than you might otherwise get. those are two different data sources, one coming directly from the census, another informed by the census. But all of them involve public data. And all of them involve a methodology that is also public. So I don't know that, at least the particular method that Mr. Harnish was mentioning, I don't know that there's anything private or proprietary about that. The individual choices that any analyst will make, which races to include or how to do that evaluation specifically, those may be individual choices tied to your analyst or your particular choice of consultant. But neither the underlying data nor the methodologies are secretive, if that makes sense, if that's a good clarification. Now we have to measure the extent to which the state law limits your choices in that regard.
I would agree with that and add the caveat that we don't yet know the validity of the census data, particularly as far as California is concerned. I don't know how the statewide database is going to deal with census data if it doesn't include undocumented immigrants. So I think we can specify that public information be the basis for any analysis, but at this point I would not want to limit what that public data would be.
Got it. Then are we tied to the same methodology that is used, or can we have a contract where a person uses their own methodology?
The methodology would be the consultant's methodology.
Commissioner Sadwani?
Sure. So if I can just weigh in. So BISG refers to one methodology, as Professor Levitt very clearly kind of laid out. Bayesian improved surname geocoding. And for all of those for all of the reasons that he laid out, it's very difficult to identify voters. Surname matching is the method used by the statewide database. I would absolutely agree with the caller that he should only be using statewide database data and or ACS data, the American Community Surveys data, if we choose to use the BISG. It is a part of a package that he developed, but it is one option in that package. I've used that package. I've actually used that in my research. And what's nice about it, it's an R package. R is a statistical language that can be used in the program. What is new about it is not any of the methodology that's being used, with the exception of BISG. It actually allows you to conduct ecological inference, which is the statistical method that's used for racially polarized voting. There are a couple different methods of doing that. There are Goodman regressions, King's method, the Rosen method, and what EI compare, which Professor Barreto had done his presentation on previously, using that package, that statistical package. The reason it's called EI compare is it actually runs the data through all of those different methods and allows you to compare them across to ensure that regardless of which method you're using, which statistical method you're using, that all of the data is going in the same direction. My recommendation would be that assuming we're going forward with Professor Barreto, that we would ask him to conduct both kind of the traditional analysis using CVAP, citizen voting age population, and the new BISG using publicly available ACS, American Community Survey data, so that we could see both. I agree with the caller that BISG is newer. We wouldn't want to tie our hands using only that, but I think if we can actually get both conducted, we would have a whole lot of data at our disposal.
And just to add 15 seconds to Commissioner Sadwani, thank you, by the way, for reminding me about the acronym. All of the methods, all the different methods that Commissioner Sadwani just mentioned have all been approved by various courts. So none of these are sort of newfangled in the way that the courts aren't recognizing. Some of them have been developed more recently than others, but courts have actually validated each of the components that she just mentioned.
Thank you.
Okay. Do we feel that we have exhausted our discussion to the point where we are ready to vote, or shall we break for lunch, take public comment as usual after lunch, and then hold our vote? Commissioner Ahmed.
We actually can't vote right now. We're missing 3 people. And it's a special vote, correct? So we're missing Commissioner Kutagawa, Lamont, and Toledo.
They're from different groups.
We could vote, but the vote wouldn't succeed. Okay. Then I think we are in a position where we need to hold off and break for lunch, be back at 1:50, and we should be able to take our vote on the motion at that point.
Actually, one quick thing, Commissioner Sadwani won't be here after lunch. So could I ask one quick question of her before she takes off?
Yes.
In the scope here. So just, I think Mr. Claypool said, what we're voting on here is essentially to get the council to start roughing up a scope. It's then going to come back to us, the actual details of this. It's not like, okay, this is generally what we're doing, and then just go. We don't see it again. Or what are we actually exactly voting on?
My sense is that we could go either way. In all honesty, if the commission feels like we want to see the interagency agreement and approve it in advance, and I think a part of it is I don't know enough about how the interagency agreement works. So if Director Claypool feels like it's prudent to return it to the commission, I'm perfectly fine with that. My understanding previously was that RPV analysts were simply hired by the VRA Council of 2010. I don't know if that was approved by the commission, but I see Marion shaking her head. So please let us know what you would recommend.
It was a contract with the commission last time.
A contract that the commission approved.
Yes.
Got it. Okay. And in the interagency agreement, is it then the case that the monetary request, et cetera, is negotiated then between the attorney and the analyst?
Sure.
So then it sounds like then there would be a negotiation between our counsel and the analyst, and then be brought back to us for final approval.
Yes, it's going to work like any contract, and we want our chief counsel to have a lot of input in this, and to make sure that we've looked at the terms of the agreement and everything else. So it's going to be a typical contract, and we're going to need to reach out and work this out. That's why I talked about it being a draft. It can be done very quickly, but I think that you'll want to know this commission will want to know what the terms are and everything else and what they're getting before they sign on to it.
Very good. Commissioner Fornaciari.
So then do we need to vote now? I mean, do we need to vote at all? Or can we just give direction to the staff to go do that and bring it back and then we vote on it?
That sounds like a good idea. Marion, can we?
That would be fine.
Okay, then we would ask staff to prepare a draft for our consideration.
And of
Director
course,
Claypool.
If Commissioner Sadwani wants to modify or withdraw her motion.
Sure, happy to do that if we can move forward.
And of course, this is going to move through the subcommittee. I mean, we're going to draft and they're going to approve and so forth. So it's going to be a coordinated effort.
Very good. Commissioner Fernandez? No? Okay. Director Claypool, are you okay with the direction given?
Absolutely.
Okay, very good. Professor Levitt, thank you so much again for your generosity and sharing your expertise and devoting so much time to us. I feel like you're our coach in the background, kind of.
If I'm the coach, it's a spectacular team that I'm helping to coach. So thank you all for being on the team.
And we will break for lunch and be back at 1:55, please. Thank you, everyone. Hope you had a good break. Welcome back. As usual, we will begin the afternoon session with an opportunity for